I'd start by opening it up to any questions that people have, and if there are no questions or there's not a lot, then I'll go ahead and start talking about estate planning and then dealing with the elder law aspects as well. So, you know, this seminar is yours basically, so I'm here to answer any questions that you may have, or if there's any topics you'd like me to talk about. So, we do have one question.
Yeah, you mentioned this special care key. And
Special
I have,
needs trust?
Yeah, I have a client who is retired, and she has a special care kid,
Okay.
not kid, 40-something years old, and she bought a long-term care insurance for me last year, and
Okay.
on that point, I thought it's better to, I didn't realize that could be an issue for in the future if this disabled son become a beneficiary of that long-term care insurance policy. If anything happens to the client, then this son will be inherited a big chunk of the.
Okay. What's this, the child's disability?
He has
Mental
a
illness?
Down disease.
Down syndrome?
Yeah, that's right. Down syndrome.
Yeah, in that case, I mean, what she should do, if she doesn't have a living trust already,
She has.
so she should have her living trust, and what it should say is that when how many kids does she have? Two? Okay. I'm just gonna assume she's giving everything 50-50, but maybe it's a different percentage. That she should have it set up so that when she passes away, 50% will go to the, healthy child, right?
Mm-hmm.
And then the other 50% will be put into what's called a special needs trust. Okay? And then the beneficiary would be that disabled child. Now, the person that could be in charge of this could be this person, it could be a professional trustee, it's whoever she's comfortable with. But what's going to happen then is any money that's in this trust is protected. So if this child, the child's probably already on SSI and Medi-Cal if he's 40. Yeah. So, any money he receives is going to disqualify him from those benefits. So instead, you put it into a special needs trust. And what the trust says is that it can be used for things other than those things that SSI and Medi-Cal are paying for. And so in other words, it's not going to be paying for medical expenses otherwise covered by Medi-Cal or Medicare if he's on Medicare. If he's disabled, he probably has Medicare also, or he may have Medicare. It's going to pay for things that those aren't going to cover, such as furnishings, entertainment expenses, maybe therapies that Medi-Cal is not covering, those types of things.
What about the welfare? Because her son is currently receiving the welfare from the state.
So, yeah, again, it's not, as long as the money stays in here and it's used for things that aren't covered by these other benefits, it'll be protected. And so he'll still be able to continue to receive the benefits. And at no point is the money ever to be given to him directly, okay? So, this is a very common planning strategy for people that do have disabled children. It's been around for a long time, but a lot of people don't realize that. There's one attorney that I know who's, what he tells people is if they have a disabled child, just disinherit them and tell the other kids to, use that piece of what that person would have otherwise received to help care for them, which is, to me, horrible advice, because one, there's no guarantee that the kids are going to do that. Two, they can completely screw up that one child's benefits if they're given money and that type of thing. So this is the proper way to set up for someone who has a disabled child, is to do the special needs trust.
So my client has a living trust. Only thing that, is there any conflict between the special need trust and regular living trust?
No, because this doesn't get funded typically until she dies. So she says in her trust that I give 50%, 20%, whatever she wants to give to this trust at her death. So, there's really no issues. I think we had a couple more questions, so.
Mine was about tax implications of that, like the debt, when you transfer the money, will there be taxes?
Okay, well, so when this person dies, let's just say this isn't set up yet. So this person passes away. To the extent that their estate next year is going to exceed $1 million, there'll be an estate tax. Okay. This year, there's no estate tax at all. But next year, and again, unless things change, it will be $1 million exemption. So after the estate tax is paid, and any other expenses, the mortgage or credit cards or whatever, then, you know, in this case, it's split 50-50 or whatever. There's no then taxes on the transfer. It's just like anybody else received the money. But once the money's here, okay, you know, and here's the beneficiary. At this point, then, the trust is the taxpayer. And so if it earns income but doesn't spend it for this person, the trust pays taxes on it, the trust tax rate. If any income is paid out to this person, then it gets reported on this person's tax return at their tax rate, which would be minimal, if any. Okay? But there's no actual tax on the transfer because it's subject to a state tax to begin with, so there's no separate tax.
Are there any other structures where you can pass the inheritance without incurring huge
Estate taxes?
Yeah.
Well, yeah, I mean, there's things that you can do if, you know, you have a large enough estate. There's things that you can do to minimize estate taxes. One of the best things to do, and the easiest, is you can purchase life insurance to be used to pay estate taxes, and then you transfer it into an irrevocable trust. And so when you pass away, that life insurance is not subject to estate tax, and there's a large amount of money, you know, that can be used to help pay those taxes. There's other kinds of trusts that you can set up where you transfer an asset, but you reserve the right to use that asset for 2, 3, 4, 5 years. And so even though you're transferring it ultimately to your kids, for example, the value of it is not, you know, let's say it was $1 million piece of property, okay? Because you're using 5 years of income from that property, the value when you give it to your kids is not $1 million, it may be $300,000. So you've gotten it out of your estate for $300,000 of reportable gift as opposed to $1 million, okay? You can set up charitable trusts. There's a lot of different things you can do to minimize estate taxes. To eliminate them entirely, you can give everything to charity, but your kids typically don't like that option. So
That's why I said
I think you had a question.
Well, I wanted to know about the administrator and the way that the child would be paid. Is there a minimum that can be given out at one time? I mean, can the child write a check from this estate, like, to a maximum amount?
Okay, so basically, once the money's in the special
Yeah.
needs trust, okay. The way the special needs trust has to work is that that disabled child or the disabled beneficiary has no right to the money in the trust. In other words, whoever's in charge of the trust, it's in their discretion to pay for things for that disabled child.
Okay, so they'll pay the rent or mortgage or whatever it is.
They could, yeah.
They'll pay for
And, you know, if the disabled child's on SSI, okay, which is very typical,
Mhm.
any money that's used to pay for housing expenses, so if they were helping to pay the rent or a mortgage or whatever, that will result in the SSI for that particular month being reduced. It won't be eliminated, but it'll be reduced because that's considered in-kind support. Payments for shelter and food will reduce the SSI that someone can get up to about 1/3 of the SSI amount. So it's not going to eliminate it, and it may make sense to pay, you know, for the mortgage. So as an example, let's say the mortgage is $2,500. Well, that makes sense to pay $2,500 to lose $200 of SSI. It makes sense to do that, okay? As far as who's in charge, it can be another sibling. It could be a bank or a professional trustee. My recommendation is if the disabled person is mentally ill, okay, so they're going to be difficult to deal with potentially because they're bipolar, schizophrenic, or whatever, I really tell the parent that they really should use a professional trustee because they don't want to put, you know, their other children in the position of having to deal with this mentally ill person, you know, because it may be rather difficult. Whereas if the person has a more severe disability such as Down syndrome or some of the other chromosomal issues where they really don't have any competency at all,